Hi there, this is Chapter 1 lecture video. You should have already read Chapter 1 and you should pull up your PowerPoint for Chapter 1, have that in front of you, and have your textbook in front of you. I recommend that you just listen to the audio of this lecture video and instead pay attention to the PowerPoint slides and the textbook, and I'll refer you back and forth to both. If you do need to see the closed captioning, you can press on the CC button to see closed captioning of the video if you do need that. So let's first look at slide 6 of your PowerPoint for Chapter 1. Evidence defined is some fact that tends to prove or disprove the evidence or the existence of an alleged fact. That could be testimonial or physical evidence. In court, that includes testimonial, which is a witness under oath, and it could also be documents, physical evidence, written, printed, or electronic, tangible objects, physical items, and that's called real evidence or physical evidence, which we'll talk about later. It must be legally obtained. To be admissible, it must have been legally obtained, and there's a Mapp versus Ohio case reference that. I'm going to skip to slide 9 of your PowerPoint. Burden of proof. The amount and quality of evidence necessary to establish each element of crime is the burden of proof. Beyond a reasonable doubt, at criminal trial, the prosecution must meet this burden beyond a reasonable doubt, which convinces the trier of fact that the defendant is guilty. Defendants are presumed to be innocent at the beginning of the trial, and the burden of persuasion is on the prosecution. The standard does not mean proof beyond any doubt, but just beyond a reasonable doubt. Let's look at page 5, beyond a reasonable doubt defined. It's proof that precludes every reasonable hypothesis except that which the law requires for the case. In criminal cases, the accused's guilt must be established beyond a reasonable doubt, which means that facts proven must, by virtue of their probative value or force, establish guilt. Let's look at page 6 of the textbook, the first main paragraph. The prosecution is required to fully satisfy the jury that the defendant committed each crime that is charged. The prosecutor must look at the definition of each crime and make sure that the proof has been presented on each element of every offense. Many states have standardized jury instructions for each offense for the judge to read to the jury at the end of the trial. Prosecutors frequently use these instructions to help itemize what they will establish throughout the trial. The defense does not have to prove that the defendant did not commit the crime or suggest who the culprit was, but as a practical matter, the defense is more likely to have a stronger case if they do have evidence that they present. Let's go ahead and look at the second to the last paragraph on page 6 of your textbook. There are some special situations in which the defendant does have burden of proof. These are affirmative offenses. That would be if the defense is self-defense, that the act was committed under duress, intoxication, entrapment, or the insanity defense. Those are good examples of affirmative defenses. And the defense must introduce evidence on these issues. Some states require the defendant to prove them by preponderance of the evidence. On page 7 of your textbook, actually we won't go there quite yet. Let's go to slide 10 of your PowerPoint. Judge and jury. The judge is the trier of law and always determines what the law is on any given point. If there is no jury, the judge will also determine the fact of the case. The jury is the trier of fact. They determine if the evidence is to be believed and what weight to give to the testimony, to the physical evidence as well. On page 7, if you look at role of judge and jury, the second paragraph, after consultation with the attorneys for both sides, the judge will select instructions for the jury that explains the law that must be applied to the case. Errors in selecting jury instructions may be grounds for reversal or for reversal of a conviction. Not as obvious, but equally important is the role of the judge in deciding what evidence is admissible at trial. If a statement is privileged, the judge must exclude it unless there is an applicable exception to the privilege. We're going to talk about privilege communications later in this textbook. If a confession was obtained by coercion, the judge must exclude it. Even in these examples, the judge must analyze the facts and conclude that the privilege applied to the conversation or the tactics used to obtain the confession were coercive. Judges are also allowed to do legal research or have their law clerks conduct legal research for the basis of the judge's decision. So that's just some information that's helpful for you to know. Slide 11, admissibility. The judge does control what evidence will be admitted. A presumption exists that the evidence is admitted unless it's objected to. So that's up to the other side to object to any evidence that's introduced. Judicial discretion. A judge determines competency, relevancy, and materiality of evidence. The judge also looks at how prejudicial evidence is, and the judge may decide evidence cannot be admitted because of that. One of the things the judge may look at could be photographs. If photographs would create too much emotion, or maybe a video might create too much emotion, the judge might decide certain photographs for a crime scene to be admitted and certain that may not be. So that's something that can happen too. Let's look at page 8 of your textbook, third paragraph. Other rules of evidence call for similar determinations by the judge. Evidence that's too prejudicial, extremely graphic, I just mentioned that. While the jury needs to know the facts of the case, there is a belief or a danger that exposure to photographs that emphasize the gory details will cause the jury to focus on the horrific nature of the crime rather than proof that the defendant is the person who committed it. More and more photographs have been admitted as our society allows, accepts those things to be seen, and in many years past, certain types of photos may not have been entered before that are now. So it does change with society. Let's look at slide 12, Apprende versus New Jersey. The Supreme Court limited the judge's power to include any fact in sentencing. Only those facts shown beyond a reasonable doubt may be used to determine the maximum sentence. The judge used information not conclusively proved to expand a sentence 2 additional years. That wasn't fair. Apprende may have committed the crime because of a racial bias, but if not known beyond a reasonable doubt, you can't use that in sentencing. So that case helped establish that it has to be proven beyond a reasonable doubt for it to be counted towards sentencing as well. Slide 13, let's look at the prosecution's role. The prosecution often initiates the criminal proceedings. Federally, they are called the United States Attorney. State prosecutors are usually called district attorney. Well, you have a district attorney that oversees the entire district attorney's office, and then you have deputy district attorneys who are the attorneys that prosecute cases on the state level. Prosecution represents the state or government at trial. The prosecution also handles all appeals of verdicts. The lead district attorney is an elected person, and deputy district attorneys are hired. Slide 14, before trial, prosecutorial ethics. Seeks an arrest or search warrants only with probable cause, so they won't try to get an arrest warrant for someone if there's not probable cause. Disclose all useful evidence to the defense, so they have to disclose evidence. They have to prevent undue publicity, so they don't try to get the citizens on their side through the media. Ensure constitutional safeguards are followed. The prosecution does assist police to ensure proper warrants are issued and used, to determine if any act committed is or is not a crime, and to help train the police in the matters of law. Slide 15, from the arrest to the trial. Preparation. For minor cases like traffic tickets, generally will only read the police report. For major cases, the prosecution will need to interview witnesses, and that may be an investigator that works for the prosecution. Review evidence, determine the likelihood of conviction, look at the level, number, and type of charges, and determine if a plea bargain is more appropriate than going to trial. Page 10 and 11 of your textbook. Page 10, third paragraph. Part of the prosecution's role is to review the actions of police officers and make judgments on whether they were appropriate. The result may be refusal to file the charges requested or possibly not filing the case at all. Conflict also arises because the police are allowed to base their decisions on all the evidence they've legally obtained, while the prosecutor makes decisions based on what will be admissible in court and what will convince a jury to convict. The police may have relied on hearsay that cannot be used in court, or the witness may have a sordid past that will make the jury maybe not trust the testimony of that witness. Page 11, second paragraph. The Sixth Amendment right to counsel attaches to the first court hearing. The prosecutor is ethically bound to make sure that the defense is advised of his or her right to counsel and to refrain from contacting the defendant directly. the prosecution can't contact the defendant directly. The Supreme Court held due process demands that prosecutors reveal exculpatory evidence to the defense in a timely manner. While the case law is focused on pretrial disclosure, the ethical duty extends to information obtained after conviction.